Court.
Good morning, good morning, good morning. Thank you very much. Please be seated. Please call the case.
Good morning, Your Honors. The matter before the court this morning is a case entitled In Re Burchard Road Petition to Abandon Land Use Permit Denial, case number 24 AP 039. Representing the appellant, Myrna Nathan, is attorney John Anderson. Appellees Adam Beasley, Kathleen Beasley, and Michael Beasley are self-represented.
Okay, thank you, counsel. Come on up, and if you would, please, for the record, introduce yourself and identify your client before you start.
Okay, I'm John Anderson. My client is Myrna Nathan.
Thank you very much.
Good morning.
Good morning.
My prepared argument runs less than about 4 minutes. I would like to reserve any time I have after your questions, if there is any, for rebuttal. My client seeks one single opportunity to participate in the consideration of appellee's petition to abandon an Act 250 permit containing conditions protecting my client's property. In 1993, my client, with her husband, who has since died, was granted party status in the initial permit proceeding. Act 250
is the concept of abandonment in the Act 250 proceeding, is that a question of fact or is it a question of law?
Excuse me?
Is it a question of fact, abandonment of an Act 250 permit, or is it a question of law? For example, do you need to show specific facts that it's no longer being used or whatever, or is it just an automatic issue that's contained in the law saying if this happens, then the Act 250 permit?
No, I think the test, it's not a question of whether it's continuing to be used. It's a question of whether construction was done, whether the permit was used.
Okay.
And I think that, I guess that's a question of fact. That's a question that we would like to argue and treat, but we weren't allowed to even enter the proceeding so that we could address that.
So you'd like to have a hearing on that specific?
Yes, yeah. The motion that I filed had two parts. One was that you need to reopen or it should be reopened. And the second part of my motion, which was never considered by the court below, was that once you reopen it, you should void the abandonment. I'm sorry for the double negative, but that's what it is. And the court below simply said, we're not going to consider the issue of whether the permit should be abandoned or not. We're just not going to let you into the party so that you can question that.
I have a question on the notice issue. Apparently a notice of the environmental division hearing was sent to your clients, but at an address apparently that they don't use for mail. And I'm wondering, doesn't your client have an obligation, as she's alleging she's a party, doesn't she have the obligation to make the court and or the board here aware of her current mailing address?
I believe no. The answer to that is an absolute no. This was not permits issued. The people go on with their lives. After 30 years, the appellees wanted to abandon the permit, and it is up to them to provide a listing of the people who should receive notice.
But they did that.
Did they?
But they did that.
They did that, but they provided an ineffective address for my client. They provided the physical address of the property in Dover. They did not. The usual practice is that you go to the town clerk's office. The Act 250 coordinator even referred the appellees to the town clerk's office. You get the grand list addresses. and you use those in giving Act 250 notice. Had that been done, my clients would have gotten their notice at their home in New Jersey, and they would have participated.
But counsel, wasn't there also notice published in the Deerfield Valley News?
There was, but I'm not aware of any case that's ever said that published notice is sufficient if people didn't get the notice that they should have gotten because of the mail notice. My clients are going on with their lives. My client lives in New Jersey. She's 85 years old. She has a son who manages her affairs in New Jersey, and she has another son in Massachusetts. There's no reason to believe that a single publication in a weekly newspaper in Dover, Vermont would have ever been effective to reach my client. And to get back to your question, it's for the very purpose that people don't have an obligation to report where their addresses are, that people who are moving for relief before the environmental board or before the district environmental commission, including filing for permits, they have to supply the addresses and effective addresses for the people to whom notice should be sent. You think about it, how many permits do you think might benefit your house? There's no obligation for you to keep track of those permits and as you move around and report the location, your location and your address.
So what should the appellees have done here?
They should have done what any competent Act 250 practitioner does, and that is you go to the town clerk's office, you gather the accurate addresses from the grand list, and you provide those to the coordinator.
Right, I understand that, but what I was going to say
Oh,
was,
sorry.
I'm
never rude. I'm often.
I didn't take it that way at all. I didn't mean that. So that wasn't effective. So publication was made. And isn't that what our laws require or allow for? If notice isn't sufficient, publication, sometimes publication is used without even trying notice first.
In Act 250 law, they're both required. It's not like a civil proceeding where you try this and it's a last resort. You give notice in the newspaper. They're both required. And in this case, the agency didn't follow its own rules.
What is the purpose of notice in the newspaper? Isn't it to
really,
give notice to people who otherwise don't get it?
It's really sort of a last resort. What more can you do? You have to give notice to the usual suspects. There may be other people who are interested. We don't know, but it's a effort to give as much notice as you reasonably can. So in almost all, as far as I know, all permitting proceedings, municipal and Act 250, you're required to give notice to the people who are abutters, in this case, or the equivalent of that. In this case, people who participated previously in the proceeding, and then you give newspaper notice, and you also put notice usually in the town clerk's office, so that maybe somebody will see it. But in all cases, you're required to give notice, and it's usually mail notice, effective mail notice to the people who are most likely to be impacted by the proposed.
Others.
You filed a Rule 60B motion,
Yes, sir.
right? And the environmental court had a problem with that, given the language of that rule. What do you say about that?
Well, in fact, I was aware that parts of the 60B do not apply. And so my motion was actually broader. It was based on In re Conway, and it was based on Rule 38. But if if I'm limited to Rule 38, or excuse me, to Rule 60B, the Rule 60B is applicable to the environmental court proceedings by way of environmental court rules. Rule 5 of I think it's Rule 5, might be Rule 3, says that the rules of civil procedure are applicable only insofar as they're applicable to the environmental court. The reason for that was that it was a very short time period, about 6 or 7 months after the environmental court was set up to receive Act 250 appeals until it had to be in operation to receive them. And I was there, participated in the preparation of those rules. The best job that could be done in that time was done, but it was realized and specifically stated in the environmental court rules that we can't be sure that we've covered all the contingencies, so it's applicable only as applicable.
So you're saying Rule 60 does not apply?
I'm saying that Rule 60 applies insofar as it's applicable. The difference here is that between this proceeding and a normal civil proceeding is that in a normal civil proceeding, the parties are summoned.
Right. There's no rule for summons here.
Yeah, and the notice provisions for permit proceedings, I think as they have to be, because who knows all the people that should be invited to the party.
Well,
But they're not summons rules.
But you have to give notice to adjoining landowners. You have to give notice to adjoining landowners in Act 250 proceedings.
Normally in an Act 250 proceeding, you have to give notice to adjoining landowners, and there's a whole list of statutory parties who are people in the state of Vermont and the town. In this particular case, in an abandonment proceeding, Rule 38 covers who gets notice of that, and it specifically requires that people who were parties to the original proceeding have to be given notice.
So what notice was sent to maybe to the wrong address, or was sent to where the property is located? Is there any evidence anywhere of what happened to that notice? Did it get returned? Did it get delivered? Did it get lost?
I'm told, for what it's worth, that the Environmental Commission doesn't track, they send out the notice to the addresses they're provided. They don't keep track of what happens to it after that. What we do know is in this particular case that my client's 85. She's essentially turned her affairs over to her son. Her son reads her mail, and he has said without contradiction that no notice was ever received by them. And I've cited cases that say that means notice was never.
I'm sorry to interrupt you, but I want to make sure we get our questions in before we run out of time. You mentioned the Conway case, but is there evidence here of the appellees intentionally providing the wrong address from your point of view for your clients?
I think it's speculation on my part. I would note that the addresses that they provided for many other parties include the address of their home in another state or of their location in another state. In this particular case, they did not provide that notice. But whether or not it was malevolent or not, it was not provided. And the bottom line is, I mean, what's wrong with, if they've got a good case, what's wrong with opening it up so people can come in and question the case that they have? Why are we so opposed to allowing people to come in and question and participate in a case that to which the rules say they should have been invited? So I think, I didn't get to my prepared remarks. I don't know where I am in time, but I have a sense that if I've answered all your questions, if you have no more questions, I should sit down.
Okay, that's fine. Thank you very much. We'll hear from the appellee now, please. Come on up. And there's a step down if you want some help. One of the clerks, I'm sure, would be glad to show you how, oh, you know how it works. All right. You've been here before. Oh, you've not been here before.
I
All
saw
right.
that.
Well, it'll fool me. You understand you've got 15 minutes and the light will go on when you've got a little bit of time left, yes? Okay. So please introduce yourself if you would, identify who you are for the record, and then you can start.
Thank you. Good morning. My name is Kathy Beasley. I'm appearing pro se as an appellee in this case, along with Adam Beasley and Michael Beasley as the other appellees.
All right.
The issue that is before this court is the Superior Court's ruling on a Rule 60B motion. Rule 60B of the Vermont Rules of Civil Procedure states, the court may relieve a party or a party's legal representative from a final judgment, order, or proceeding for various specified reasons. There was a final judgment in a litigated proceeding before the Superior Court that led to the 60B motion by appellants. The Superior Court, in response to that motion, held that appellant, who was a non-party to that final judgment and not subject to any obligations under that final judgment, is not entitled to relief under Rule 60B. The Superior Court correctly ruled that regardless of this whole unsubstantiated notice, purported notice defect, and I'm happy to take questions about that if there are questions later. But regardless of that, and that notice, that purported notice defect was 2 years ago back at the District Commission. It was not in connection with the order that's on appeal, the judgment that's on appeal. Appellant Myrna Nathan does not have the kind of interest that could qualify for any exception to Rule 60B's requirement that it be brought by parties. The judgment does not concern the issuance of a development permit. It doesn't concern the granting of any development rights. It concerns the exact opposite, the abandonment of a long unused and expired permit.
Can I ask you a question? I
Sure.
think this is a good point or a good time. Was the entire project abandoned? Was any of it, I was confused about that. Was any of it started?
No, the entire project was abandoned. The permit was issued in 1993 in connection with the extension of a residential development that had been grandfathered that predated Act 250. So there are houses like the appellants in the area that abut the land that was the subject of the permit. But the land that was the subject of the permit went 30 years completely undeveloped, none of the infrastructure, no houses on the permitted land. So, and as Justice Cohen pointed out a moment ago, there is a statute that deals with abandonment. It's 10 VSA section 6091, and it specifically defines what use means for purposes of the statute to constitute or not allow abandonment of a permit. So what is sufficient to avoid an abandonment determination is that the statute requires both that construction commence and that substantial progress toward completion of the project occur within the first 3 years after issuance of the permit. 6091 is clear that abandonment of a permit has occurred. It just has occurred if no substantial progress toward completion of the project has occurred in the 3 years after issuance or other extensions.
So it's really not a question of fact, it's just an automatic termination of the permit if in that period of time, no construction or nothing's done in order to start a project to begin.
That's correct. It is not a weighing of interest. It's not like you think of other things like a granting of a permit, like in an Act 250 proceeding. An abandonment is a statutory standard. It's not a weighing of interest or considering people's, thoughts and feelings about it. So both the permittee, which at this point is appellees. We obviously are successors in interest to the people from 1993 who didn't get their development done. We just purchased this property in 2022. But both the permittees and the Natural Resources Board agreed that the facts supported a mandatory abandonment declaration pursuant to the statute. And as N. Ray Butoff makes clear, when that statute is met, when no substantial progress toward completion of a permitted project has occurred, a determination of abandonment is mandatory. So again, not a weighing of interest. It's just if you don't do it, it's abandoned.
So you would be prohibited from undertaking any development activities based on the permit.
Absolutely, it's expired.
And that was my next point, is that it's expired as a matter of law.
That's correct. By its own terms. It has deadlines. Those deadlines are long past and nothing happened. And so, yes, it is expired. It is unused by the terms of the statute. And that is why it seemed pretty clear to us when we went in the petition that abandonment was not only appropriate, but.
So why would notice matter if it's an automatic termination notice to, parties to the original permit?
I'm sorry?
Why would notice be required, with your argument to any entity that was a party to the original permit when it was issued in 1993?
So the only notice requirement that appellant has pointed to is Act 250 Rule 38. So it's not a procedural rule, it's not a statute, it's a NRB rule in their proceedings. And that rule provides that in a situation somewhat different than this one, it says if it's an abandonment proceeding where the district commission retains jurisdiction and they treat it as a contested case, they are to provide notice to a list of entities. Abutters are not on the list. But one of the things on the list is prior parties to the permit proceedings. And I would like to point out here that rule being the only notice requirement anywhere that's relevant to this is not an obligation on petitioner. It simply says the NRB will provide this notice.
Well, yeah, but your obligation is to provide them with the names. Don't you have an obligation to do that? Interested parties, I'm sorry.
If you are applying for a permit, you have that obligation.
I thought under the statute, you had an obligation to provide them with the names and addresses of the interested parties. No?
That's in the event of applying for a
You have
permit.
a law degree, Ms. Beasley, may I ask you?
I'm sorry?
Do you have a law degree?
I do.
You do?
Yes.
Chief,
Are you admitted in this
That's
state?
the question.
You're not? Oh, well, congratulations, you're doing a very good job, but can you answer my question?
Yes, the statute and the rules so the statute that deals with abandonment doesn't speak to that at all, 6091, but the NRB rule.
It's the rule, it's the NRB rule,
but it doesn't say that the petitioner has any obligation with respect to providing that information. It just says, because the NRB has already issued a permit, so they know who was a party to the permit proceedings. It makes sense. And also, there's not the same, substantial interest in someone objecting to an abandonment. Because in the event of if the statute has been met, if the standard has been met, it just is abandoned. And it's a matter of having a declaration. It's not like, again, getting everyone's opinion about it.
Is it necessary to have a hearing on that issue? I mean, what can the court do? The law says the permit's kaput.
It's an interesting question. There are cases, so in fact, Vermont Supreme Court cases that have said the statute appears to be self-effectuating, but that the NRB has chosen to set up a process to go through to make that declaration. And I should have said earlier when I was saying that how this one differs. Ordinarily, that would be expected to take place in front of the district commission where that determination would be made. In this particular case, they did not treat this as a contested proceeding over which they had jurisdiction. The order in the district commission was specifically that they did not have jurisdiction and they deferred to the Superior Court. So it was the district commission who actually insisted that we go to Superior Court Environmental Division to get the abandonment, because there had been a court order back in 1989 that started the whole development process. And they said, well, if there's a court order that started it, we want a court order to end it.
I'm gonna guess Wake Forest. Is that right?
As the case or,
No, your degree.
oh, no, no, Your Honor. My law degree is from SMU.
SMU,
Yes.
Texas. All right. Okay, what else you gotta say?
So I guess what I would like to point out in terms of, Rule 60B and its requirements, that overturning the Superior Court's ruling in this case would require the court to hold that a non-party to a court's final judgment, like appellant, can move under Rule 60B, which would contradict both the rule, the words of the rule itself, and all existing case law in any jurisdiction.
Yes, it would essentially blow up Rule 60B.
It would, because the rule itself says you have to be a party or a party's legal representative. And also, the rule says it's for relief from a judgment. And here, there are no obligations on appellant contained in the judgment. It doesn't relate to her at all. So she's not actually seeking any relief from the judgment. She is seeking to void the judgment as to the NRB and appellees, which is not something that the rule was set up to do. The NRB supports the judgment. The NRB filed an opposition to the motion for relief in the Superior Court, and their brief is also in the appellate record at page 31.
Ms.
So-
Beasley, can you just briefly touch on the issue involving the mailing of the notice to the address of where the property is located?
Sure. Just generally?
Yeah, sure.
Okay. So again, the rule speaks to the NRB's giving of notice in the event of a contested proceeding over an abandonment. And in this case, the petition for abandonment was filed in April. The email that appellant has pointed to make this argument came in July. And it was not a request related to parties to the permit proceedings, which is the notice requirement, Rule 38. It was a request for a list of abutters. So what had happened is that there had been 3 months after the petition had been filed where the district coordinator was not putting this in front of the commission, but was instead asking for more information. So we had gotten a series of requests for additional information. We need this, we need that, we need this other thing. And in July, there was an email that said, we need a list of abutters. And that's the email that they've pointed to try to shift the burden over to the petitioner with respect to the prior parties to the permit proceedings. We provided a list of abutters. And the NRB, we don't have personal knowledge of how they went about deciding, but there's a certificate of service in the appellate record where the NRB technician certified service to the parties that they chose to serve under their own rules. None of that is petitioner's obligation, nor did we have any specific insight into how that took place. So they didn't ultimately, though, treat it as a contested proceeding, as I mentioned. What the district commission ruled was that they didn't have jurisdiction, and they said, go to the Superior Court. So we went to the Superior Court. As the court pointed out earlier, there was, in addition to the fact that the notice was mailed in accordance with the certificate of service, there was also published notification. And does that mean I'm out of time? Or 1 minute?
Oh, that's your warning.
I've got my 1 minute.
Can I interrupt?
Sure.
Right when you have a minute left? I'm wondering why, how is it that, and I don't disagree, that really the appellant can't do anything about preventing an abandonment once it's in court? Why does Rule 38 require that that person get notice then, if they really can't do anything?
It refers to parties to the permit proceedings.
Yeah.
And again, just to be clear, Myrna and Donald Nathan, her late husband, had submitted a request for party status back prior to the 1993 permit on the basis of very limited grounds of soil erosion and waste management, I think, and were granted that party status. So they were essentially objecting to the development. Now they're objecting to there not being a development. But it just says that if there's an abandonment of a permit that you've appeared or had some interest in, you'll get notice that it's been abandoned.
Right, and my question is, why would they get notice? Why would they even receive notice or be allowed to receive notice if they can't do anything about
Yeah,
it?
what's the purpose of it?
Yeah,
Yeah, I would say, that's probably a question for the NRB. I don't know. It's their rules and it's just who they give notice of. They also give notice to the city and, the town, and there's a whole list of people who get notice of things related to the thing. And if I could just quickly summarize,
Yeah,
unless there's.
We still have time, so go ahead.
Okay. The Superior Court correctly ruled, consistent with the words used in the rule itself and with all case authority in the federal rules, in the federal system, in Vermont. There's no case law that would extend Rule 60B to non-parties like the appellant. And though she argued that her motion was somehow not just a 60B motion, she identified no other procedural mechanism to challenge or set aside the final Superior Court judgment. She's not prejudiced because it is a statutory standard and not a weighing of interest. And if there's any development that implicates Act 250, again, we're talking about abandonment. So if there's any future development that implicates Act 250, a new permit will have to be obtained and people will have an opportunity to
Okay,
speak.
finish up if you would, please.
Okay. So I would just like to point out that here, there is evidence in the record, starting in 43 through 44, that the purported interest that appellant asserts is a reaction to her clearly expressed purpose of just wanting to claim the roadway property for
Okay.
herself and her family.
Your time is up. Thanks very
Thank you.
much. How much time does the appellant have, please?
Appellant has 36 seconds remaining, Your Honor.
Counsel.
I have 36 seconds to correct the statement. The issue of whether abandonment, of whether construction occurred is disputed. If you look at, I believe it's pages 98 or so through 100, it's in that area. That's my brief that argues. In fact, the district commissioner ruled that the Act 250 jurisdiction had applied to this property. Her argument is that her property, no construction was done on her property, but construction was done on other property, and it was done even after the permit initially issued. And that, sir, is why this is not a question of law, it's a question of fact. And it should have been resolved, it should have been considered, and my client should have been allowed to participate in the consideration and resolution of that issue of fact. And unless or until we have that opportunity, the facts are interpreted in our favor.
Your time is up. Thank you very much. Thank you both. Please call it.